I hope this is it. Yeah, that's it. Hey guys, can you hear me? Hey Olga. So I'm just getting started early. Amy is here with us today. She didn't realize the time difference.
Hi, everyone. I guess I'm supposed to say hi. Was that my
Yeah,
introduction?
you can
Hi,
say hi. Yeah,
everyone.
I just found the video, so yeah, I don't really have an intro set for today. Like I tried to, but um, I don't know. I just got home. I didn't really have time to actually come up with an actual welcome to timeless kind of thing.
Huh.
So, how's everybody doing tonight? How's things been going on Power Woman Radio?
Um, yeah, it's been going good.
You can call and
We're actually changing the name from Para Women Radio to the Power Network, but we haven't changed it quite yet. So it's still Para Women Radio. And yeah, we've been doing some interviews, and we interviewed Nicole Kessinger recently. Um, we talked to Kelly from What's the Obsession. I don't know, we've been doing a lot of stuff. What have you been doing?
I've been trying a whole bunch of different things. I've been trying to get used to doing live streams, and I've been trying to figure out how to do shorts and grow my channel and actually have time to sleep. It's actually quite a bit of work. I
Oh,
try
did
to
I
make.
say Kessinger? Whoops. I meant Nicole Atkinson. I think I said
Yeah, I
Kessinger.
was about to say something, but I was like, wait a second, she
Wouldn't
isn't
that,
going to interview
wouldn't that be
anybody.
something? I
But
just like off the cuff. Yeah,
yeah,
we interviewed Nicole Kessinger. Pretty cool.
yeah. You interview Nicole Kessinger, you'll be like making $1 million probably.
Something. But
But
tonight we're
yeah,
talking about Bryan Kohberger. Do you think Bryan did it?
well, the whole time I've just like had this. I've always thought he did it until, I heard that 911 call, and then I started wondering why the police said that, well, these people weren't involved. And I just always had this weird feeling, about this case. It just doesn't seem right. If you think about it, Bryan Kohberger is one person and four people died. If this was his first murder, if he did do it, that is very unlikely. Like it's not normal for a killer to start off with a quadruple murder.
Well, I don't think he did start off. I mean, well, I think that ultimately he didn't mean to start off with the four. I think that he started off with doing the burglaries where he just kind of like went into people's homes and moved things around, took a few things, and I think like this was going to be just he didn't expect the and I always thought it was Maddie that he was going after. In the very beginning, everyone's like, "Oh, he went after Kaylee." I was like, "No, I think it's Maddie." After seeing Maddie's boyfriend, I was like, "No, I think it's Maddie." But I think he went up to Maddie's room and didn't expect Kaylee to be there, so then he had to fight both of them, and then Xana heard it and went up, and then he had to go after Xana, and then Ethan was there and he had to do that, and he was just so freaking tired by the end of it. He was like just wanted to get out of the house, and he left the other two. That's
Well,
what I
see,
think.
that sounds good and all, except for one thing. Why didn't anybody call 911 until
Because people
noon
do
the next day?
strange things when they're in shock.
I don't know. Like
I
it's
know.
like
I've been in shock and I've done strange things. People, and I've worked with people that are in shock. I'm an ex social worker. I've worked with people that were in severe trauma, and people do strange effing things when they're in trauma and in the shock. But I
I
mean,
I can understand
everybody
that
can
to a
have their
point.
own opinion about it, but my opinion is that people do things, and I know for a fact people do strange things in shock.
Well, it's just weird that, if she's thinking something's happening, something bad happened at 4 a.m., she didn't go look, or if she did look, she pretended like she didn't. Which if she did look and, it was trauma, that could be why, but she hasn't admitted that she actually looked into the room. But
We
the
also
door was
don't know
open.
the full
The door
story.
was
We're getting
open. They
everything from
there
news
was
reports. We haven't gone through the case. We're getting something secondhand from a news story. We don't know everything that she's done. So we're only going by what, they're reporting from a news story. But people do strange things in trauma. And on top of it all, they were drinking, they were consuming substances. Yeah, people do strange things.
Well, I just I don't buy it. I don't buy it, the 911 call at all. Like, it sounded fake, it sounded rehearsed, and, the whole time when I was listening to it the first time, it sounded like the door was closed. If the door was closed, then it would make a little more sense that she wouldn't know that something bad had actually happened, that her friend wasn't just passed out and not waking up. But there was enough blood in that house that it was leaking out the wall.
You don't
Um,
always see what's right in front of you when you're in shock.
but the smell alone,
You
you would
don't
have
always
smelled it.
see or feel or smell. You don't always see it. Your brain is so amazing the way that it will tune things out so that it will protect you. It is amazing. I've done things later that I'm like, why did I do that? And my therapist is like, your brain was protecting you. Oh, okay. Why didn't I see that? When I almost got stabbed, I didn't realize that it was that they were stabbing at me with a knife. I didn't even see it. I didn't see it. My friend saw it.
Mm,
And I don't know how I didn't get stabbed.
that's
So,
kinda scary.
yeah.
But, yeah, I mean, I get what you're saying, and I can see it from that side, but, to me,
You don't
that's
really
just
have to see
too.
what I'm saying. I mean, you can hold the belief that, the 911 call is fishy because, I mean, if it's raising your fish, like your hackles and your back of your neck, then it is what it is. But for me, just working in the field, that's my
Well,
gut
it's
instinct.
just like when she's all like, well, at 4 a.m., her voice changed and it sounded different. Like she had been rehearsing this, that like this was part of the call that she had to say. She was like, well, at 4 a.m., there was this guy. And that was like while she's telling the 911 person that she's afraid to open the door and go into the room and see if her friend's okay. And I mean, it just I mean, it could be trauma, and I'm not gonna disagree to the extent that I don't believe it at all. It's possible. I mean,
It
I
has
don't know.
been
I
said,
wasn't there, but
it's
it just seems weird. And then, 4
that
people
friend, it's
died.
been said, has suffered. She already had trauma. Before this, there was something that had happened to her. So she was already dealing with trauma on top of trauma. And then, I mean, the fact that Xana went upstairs to see what was going on and didn't make it back downstairs to her room, to me, it shows that she was under some kind of influence because she didn't quite make it back into her room to get Ethan up, and so I don't
And
know. I think
that's
they
the
were
other thing,
all
there's 2 people there.
using
So,
substances.
both of them had the same trauma, and they neither one would call 911, you know? Like, what you
Yeah.
described sounded like this big, huge fight where 4 people died, not
Yeah.
just some quiet murder in the middle of the night.
Hmm.
So, the dog was barking, right? Um,
Oh, for sure, the dog was bark. I think
uh,
there's even a audio, like the neighbor's camera, I think caught it, the dog barking, and they caught
so
some
there would have been
sounds,
noise, and,
lots
I don't
of it.
know
But it was
if
also a party house. I lived in a party house in college, and you do learn to tune some of that stuff out. And being a 20 some, how old were the girls? 20 something or early 20s? I
20, I
don't
wanna
think
say
those two girls
21.
were
I think
graduating
20 or
quite yet.
I think
So
well, I can't remember. I think it was 21. I think they're 21 and some of them were 22.
I
They were
remember being like 20 and feeling still 15. So I don't know.
Mhm.
I
They're
just
still
feel that. So you a I just heard today the word pro burger. Are you a pro
no,
burger?
no, no, not at all. I want to know what happened. I don't necessarily buy the story that I've heard so far, but we haven't heard the whole story, so I don't know yet. But the idea that four people died from one person, it just doesn't. It's never really sat right with me. Even Ted Bundy couldn't kill four people in one night. He
How many
tried.
women did he kill at that
He killed two and he
sorority?
injured two more and tried to attack another before he got caught.
I think he got lucky with Ethan though. I think he hit the right exact artery for him. And I think the other two girls, he got Kaylee in the face and probably incapacitated her that way. So the only two that he really struggled with probably were Maddie and Xana. Xana put up one. I saw today that there's reports that Xana's fingers were almost off, like
Oh my God.
off.
Yeah. The last time I was in a fight, I think I was like 15 years old. And I remember after like one or two swings, you're winded.
Oh
And so I
yeah.
just can't imagine swinging a knife many, many times and just like surviving.
But
I
adrenaline kicks in when you fight. I remember the last fight I had was on a porch in college and I tried to push a girl off the porch and I just remember after it happened I like fell to my knees because it was just like, wow, where did that come
right.
from?
So
But
what
she
I'm
came after
thinking,
me first. It was one of those things where I realized that I never knew I was a fighter until someone came after me and I was like, wow, I don't run.
Mhm. Yeah. Well, what I'm thinking is Kohlberger either it wasn't him or he wasn't alone. That's where I'm kind of leaning towards. Because he just kind of gives off that vibe.
I
He
think
seems like,
it was 100% him or he wasn't alone, but it
yeah.
was him.
And what also has bothered me is the sheath, right? They found the sheath. And then they're saying now that 2 days later, he was looking for a replacement sheath, right?
Yeah,
But that would mean he still got the weapon. Why would he need another sheath if he disposed of the knife?
maybe he didn't dispose of the knife.
Yeah, that's
Maybe he was planning another one
yeah,
and
I
you
don't
need a
know.
sheath to sheath
If
your knife.
he's a criminologist, he's got a master's degree in criminology, so he would know more than most people that you don't keep that, and it just seems weird to me. So,
Well, if he made quite a few mistakes if he's a criminologist and if so that's not really
well,
a
you're still
workaround.
also assuming that he 100% did it.
I believe he did it.
I I mostly I believe it a little less now that they mentioned that they have proof of somebody else. Judge, oh shoot, what's his name? Oh, this guy right here. He's like, you've got until
Hippler.
Friday.
Hippler
Hip,
is
Hippler, yeah, Hippler. It's Judge Hippler. He said that the defense team has to have proof by Friday. That's in 2 days on the 23rd,
well, they
and
filed
then
something, didn't they, recently because of that new news thing that came out? I mean, that was pretty damning. I can't believe that came out just before the trial. Like, wow.
But, it makes me wonder, well, what do they have? Is it a ploy? Like, is it some kind of tactic for appeals later on? I've heard a whole bunch of things because I've watched other channels and they brought people on who know these things. And that's what I've been hearing. It could be a tactic. It could be fake. It could be just another thing they use to sow reasonable doubt, you know. But what if they actually did find somebody else and they do have a real suspect that nobody's been looking for all this time because they just assume they had the guy?
I feel like they're throwing everything at the wall at this point. Trying to get it off the table, on the table, around the table, you know.
Well, at the motion hearings, I didn't think
Is
the
tomorrow
defense
the
sounded
last
very
motion hearing,
educated.
or was last Thursday the last motion
The
hearing?
last this one that's this
Is
one
there
that I've
one
got up here on the
tomorrow, or is
screen.
there one last Thursday?
There was one last Thursday.
So that was the last one, because I heard
This
him say,
one is the one I got on the screen is from last week.
okay, so this is the last one. Okay.
Yeah, this
So
is
is
where
this
the
what we're
judge.
watching?
Yeah, I was hoping to watch it. I
Okay.
didn't get a chance to look for the spot that I wanted to play, but I know that he does say that the defense has until the 23rd to prove it. Basically, he's not going to allow this kind of stuff to go on. He doesn't want, more fake news. I forget what he actually called it, but he said the more rumors that get spread, the harder it's going to be. The whole process is going to be. So he doesn't want that. Um, if there's proof of it, he'll accept it. He seems like a fair judge.
Yeah, I like him.
But
I do like him.
I just don't know yet. I'm just really, I can't wait to find out. I feel weird about this case.
Why?
Just because the whole time I've been so sure. And then as soon as the defense says, well, we've got another suspect, it's like, oh, crap. And then I start thinking of all those little things in the back of my mind that's been bugging me. And so I'm now on the fence. I was.
I felt
sure
that
this
way
guy
about
did
the Delphi case. I was really sure about it until I started looking into it. And I was like, man, this man is not guilty. I can't believe he went away. But I feel Brian's guilty. I just, yeah, I feel it. And also with all the evidence, it just keeps, it's pretty damning. But
well, they don't really have a lot of evidence. They just got his car there, and that's it.
they got his car, they got the sheep, they got the DNA, they got
they've got trace DNA.
They got the searches
DNA.
that
It's not
done.
blood DNA.
They've got his texts, they've got his photos, they've got where he was, they've got the fact that he's pinged around that area numerous times. They've got a lot.
But we don't know if he was at these parties. There's a lot of things. It's trace DNA. It's not the same as if he accidentally cut his hand. There was a bloody glove found. The killer, if he's striking with a knife, he has there's a possibility he's going to accidentally stab himself. They found one bloody glove at this place, and nobody seems to have found out whose DNA it is. If it's not,
well, and they tore
if
down
it was
the crime
Kohberger's,
scene
they would be
before
like,
the
"Whoa,
case.
it's his. We've got his blood."
You're not letting me talk, dude. You're not letting me talk either. You're talking over me, and you're not letting me talk. I feel like
if you want to talk, go ahead.
No, let's just start watching.
Put on something if worse comes to worse. But I want to make sure we use that time efficiently. With, in addition to giving the list of witnesses you're going to call, you need to provide a list of exhibits you intend to introduce with that witness, short of obviously impeachment, so that the other side can look at those. That doesn't include exhibits that you would put in as part of redirect examination. So for example, the defense in the state's case cross-examines on some other exhibits that you didn't bring up, or there are exhibits that you didn't bring up that would explain what the defense brought up. You don't have to give notice of those exhibits. You don't have to anticipate that, in other words. Now, this is not a remedy or a right that I'm likely is going to be resulting in exclusion of evidence. It is something that you're going to have to deal with me if you're not complying with it. And I will figure out something to make sure that you do, although I don't expect it will be a problem. You should know what exhibits you're going to use, and there's no real secret here about what exhibits go with what witnesses. And I say that because there's always going to be leeway where you have an exhibit that you forgot you need to use, or a witness testifies in a way that you now need to use another exhibit. So, there's leeway there, but giving the other side a general idea of the key exhibits that will be used so that they can review those to prepare, I think is fair. The corollary to my use all the time that we have is don't filibuster. I will give an example that I have used, that I have violated my own rule in the past. When I was in your shoes, where I had a young associate handling a witness who the next witness was going to be the client, and we didn't want to get to him that day, and he kept turning around thinking he was done, and I kept going like this, meaning fill up the time. Don't do that. Use the time efficiently, but don't filibuster. I've learned to come, as a judge, you sometimes feel like your client is the jury in some ways, right? You want to make sure that that they are comfortable. You want to make sure they're treated with respect, and make sure that things go as quickly as possible for them. And so I've come to respect that. And so I tend to want to make that happen as much as possible. So, don't waste their time, either by having gaps that we can't fill, or by filling it with stuff we don't need to use where we could be going to another witness. The lawyer handling a witness, if that is the lawyer handling on direct or the lawyer handling on cross, is the lawyer authorized to speak on the issues related to that witness's testimony at the time it is being offered? And so that is the only lawyer that's authorized to speak about that witness. So if there is a sidebar, only the lawyers handling the witness need approach, if it's specific to that. If it's more general and I need to talk to more of you, I'll let you know that. But I don't want the whole caravan up here for those discussions. Likewise, please do not stretch the shirt sleeve of the lawyer who is handling it by the other lawyer constantly pulling on their sleeve and writing a note and saying, don't say it, they'll get it. Just let them do their job. I'm assuming that there is, based on our prior motions, agreement.
They all look like they're being reprimanded by
I'm
Dad.
assuming at least one of you would like to exclude witnesses pursuant to 615.
Did you watch the motion call hearing where the defense got basically told, you're wrong, you don't know what you're talking about, go sit down?
No, I haven't watched it. So I'm really excited that we're watching this. So
This one I don't think is as exciting, and like I said, I didn't have time to actually sit down and find the spot to listen to.
where she brings it up.
Well, it comes up and the judge says, hey, we're not going to just throw stuff out there. I need proof by such and such day. I think they said the 23rd. So that's what I wanted to show for sure, but I don't know exactly what the timestamp is for it. It should be coming up soon, I think.
Oh, okay. So
It's in this hearing. I just don't know when.
Oh, okay.
Because if that's the case, then they will be excluded, generally speaking.
the state's expectation that that's what would occur, and that's why we raised with the court earlier on the specific individuals that we've agreed could stay even if they haven't testified yet.
So 615 is one of those rules where if one side requests it, it's granted as a general matter. And so I'm assuming that we're going to be using 615 to exclude witnesses except those excluded by or excused from it by the court. Or you can agree not to use 615.
I want to talk about experts, though.
Right.
Experts being allowed to view other expert testimony.
Correct. Experts are generally excused from 615 because part of what they rely upon is the testimony of other experts. Part of what they rebut is the testimony of other experts. So experts generally are excluded. The parties, or in the state's case, a designated party representative, such as a lead investigator, is typically excused from it. I've already talked about the defendant's family in another ruling, and crime victims are excluded from it.
I want some further clarification with our experts.
I think you guys agreed that your investigators would be excluded from it as well.
We did make that agreement. I think that may have even been in writing.
Yeah. I'm sorry, I didn't mean to interrupt. I just had that thought. I didn't want to lose it.
So that's okay. I know the court has talked before about the live streaming and being mindful that witnesses not watch the trial when they're outside of the courtroom, just like they couldn't inside of the courtroom. What I want to know is, with experts who are allowed to be in the courtroom, can those that are far away watch the live stream version if they can't make it to Idaho?
Thompson, you have any objection to that?
No, that seems to make sense, Your Honor. And I understood that the court was going to give an admonishment, acknowledgement from witnesses as they appear.
Bailiff, could you provide one of these to each side, please? This is an affidavit that each witness will have to sign, and you hand to me as they are.
Hey, so Rose says, I worried that he's guilty but smart. You know, one of my first thoughts whenever I first heard about this case and found out that this guy was a PhD student was, what if he did this just to see if he can get away with it? Like, he planned all of these details to be found in this way, and then he still thinks he's smart enough to get away with it. I think he's a smart guy too. I don't think he's a genius. I don't think that, he planned it. Like, I don't think he left that knife sheath there on purpose.
No.
I think I'm more closer to 50-50, but right now, but I have been 90% sure he's guilty up until like last week. And my thoughts have kind of changed. And it's mostly because of that bloody glove thing that they found. And I know somebody mentioned OJ, which is, they also found bloody gloves. And I can't remember that story that well, but I know that there was like this bloody glove. And I think it got thrown out, and the jury didn't see it. And that's kind of why OJ got away with it.
No, they tried to get him put the glove on.
And that's right. I remember that.
You can't acquit. And he acted like he could put on a glove that had blood on it and had been yeah, crazy.
I mean, wasn't it like a smaller glove though?
No, he just acted like he couldn't put on a glove that had blood on it, and yeah, he could have put a glove on and got it to fit, but it had blood on and it'd been in evidence, and yeah, he just acted like he couldn't do it.
Yeah, I would.
Yeah, I would have acted the same way. Plus, he's an actor.
I mean, I guess you could, when you're putting a hand in a glove, you can also make it not fit. Yeah,
you can stretch your fingers out, or
yeah. But I thought it had his DNA in it, and that's one of the things but I don't remember that.
I don't remember if it had his DNA, but I just know that he tried to put it on, and it was a courtroom spectacle.
Yeah,
I just didn't even envision it in my mind's eye, him with it on his hand. Nope, see, it doesn't fit.
Yeah, I don't know if Kohberger did it. I just know that it's very hard. If I was a jury member, it'd be very hard for me to like say, well, he's 100% guilty. I don't have any reasonable doubt, but there's no weapon, and there's just, a tiny trace amount of DNA on a knife sheath button that, could have gotten in that house 100 million different ways. I know the most likely reason, but I'm just
I
saying for
believe he
argument's
did it.
sake. Yeah.
I believe the evidence.
I don't think there's evidence like you think there is, because what we know and what the jury's going to know
I didn't
is gonna be
realize
two
I was
different
going to
things.
come on and argue about it. I thought we were just, I mean, because like you can believe what you believe and I believe what I believe, right?
Well, you do know that the jury's not going to see all the stuff that we're seeing already.
But you,
That's what they've been doing. They've been deciding what evidence is allowed to be shown to the jury, and the jury has rules they
I
have
know
to
those
follow
rules,
to make their
Robert.
decision.
I cover
And
crime too, so.
I know, but they don't get all of this stuff that we get to see. They're only allowed to see what the judge allows, and that's why
But
these
we're having
hearings
a
are.
conversation, the court, it hasn't even happened yet. So we haven't
Well,
even
in the
seen
motion
all the,
hearing,
okay,
you
see, let me finish my thought, please. We haven't even seen all the evidence. So going into this trial, I believe he did it. And you're saying that you're 50-50 on it. So we haven't seen all the evidence. We haven't heard everything. There'll be new stuff. I mean, it keeps coming out. New stuff keeps coming out every day on this, right?
Yeah, but the difference is the jury isn't going to be allowed to use any outside information. They've got 10,000 jurors that they're going to pull from, and they're going to find the ones that don't know, that haven't been following the
Good
case.
luck with that, because now with the new Dateline thing, and they moved it to Boise, but good luck with that after that Dateline thing that came out. That's scorching. I don't think that kind of stuff should be allowed, because it's going to really taint a jury.
I
Like,
think
how are they going to find anybody?
that's the one where the judge was like, "Who leaked it?" Right?
Yeah, it's
He's pretty
bad.
angry. Yeah.
It's bad. Yeah.
But I don't know what's going to happen. I just know that, the jury's not going to have the same opinions as us, or it shouldn't. They should be
I hope
fair and
they don't.
impartial.
I hope they don't know everything we know, because if they do, then they're lying, because you're not supposed to know anything about the case like we
Well,
do.
I don't think that they probably, I mean, I imagine there's some people that don't know who Bryan Kohberger is, but it's in everywhere. It's even on, I think there's a Netflix thing on these murders now, before even the
Yeah,
trial.
there's a Netflix, there's a few Datelines. I mean, I just don't think that should be allowed. Like, and someone leaked all that stuff to Dateline, all that stuff. It's just insane.
When they say leaked, I always wonder if it wasn't like hacked and stolen too, because, people can do that.
Yeah, I believe I don't trust anybody. So yeah.
But when the jury gets their instructions on how to judge the information, they're going to have certain rules, and they have to say at least, yes, I swear that I will follow the rules. It doesn't mean that they absolutely
Have you
have
ever
to.
been? Have you ever been
I
on
had
it?
jury duty last week, but I didn't get selected. So
I was on
but
a jury when I was 18 or 19.
what kind of
I
trial?
didn't want to get selected. My dad was a police officer at the time, and I was instructed to say that by my family, like, just say your dad's a police officer and you won't get picked. And so I said it, and I got picked. I was like, damn.
Yeah, I don't think they excuse you for things like that, but they would excuse you, I think, if you said something like, well, he got arrested, so that says something. If you don't want to do jury duty, say something like that, and they won't select you.
Mhm.
Because you have to be fair, at least to, some extent. Everybody has their own biases. You, you know, we're all people, but you have to at least try to just judge it by
Or
the
you can
evidence.
just say, I can't be biased. Or also in this trial, you could have said that you don't believe in the death penalty, and then you'll get excused right away. I mean, because most
Yeah.
people don't want to sit on a jury. So
Yeah. Yeah, the trial I was called for was like a civil trial. I don't even know what it was about, but just money most likely.
the trial that I did, two guys stole some scaffolding and drove down Gratiot in Michigan with it tied to the roof of their car with shoelace strings.
Yeah.
One of the guys even was like testified against the other guy. It was crazy.
Yeah. I was half expecting, that it would be like a DUI trial or something, but
I wish I could have had a DUI trial.
I think those would be pretty boring, almost as boring as, fighting over money. Because I think I don't know. It's hard to say. I'm going to play some more of this before it gets too late.
Okay.
Going to the stand when you're called by them, specifically declaring that they have not watched the live stream. This is for witnesses who are excluded or otherwise consumed media about the testimony or evidence presented during the trial. It's not I'm not wed to the exact wording. So if you have wording suggestions, I certainly will listen to them, but that is the gist, is that they will provide such an affidavit each as they come to testify. Any concern with that?
Not with the wording at the moment. A question of clarification, though. If the case should reach a phase 2, does this admonition apply to those potential witnesses for phase 2?
So a witness who is only a phase 2 witness
Only a phase 2,
and they attend phase 1. Is that what you're asking?
if they watch or attend any part of phase 1.
Well, the problem with that is that phase 1 is also part of the state's phase 2 evidence, as is the defense's, right?
And I think that would support the need for them to be able to know it if the state's going to rely on things that
Are you talking about experts?
experts and possibly lay people too.
Oh, explain to me why lay people should be excluded from it.
I don't think they should be excluded.
So you think they should not be permitted to watch the trial?
I think I've got some double negatives going on. I think that if we get to a phase 2, I don't think that those witnesses have to be excluded from paying attention to phase 1. I think the protection for phase 1 is separate than phase 2 because of the rules of evidence that apply to any phase 2, the lack of them that apply to phase 2, and because the state's going to rely on what was in phase 1. So yes, experts and some potential lay witnesses as well.
Mr. Thompson or whoever wants to address this?
Our initial inclination is to leave that to the court's discretion. I think the whole purpose is to avoid prospective witnesses altering their testimony in some fashion based on what they've seen going on in court. That's the danger. I don't know why phase 2 witnesses should be treated any differently than phase 1 witnesses.
Well, what I'm going to do is, I'll give you a chance to each submit something within 7 days in writing on that, and I'll look at it so that you can give me any authority that you might come across related to that issue. Give me a chance to think about it further, and for the two of you to perhaps talk to see if you can understand specifically who you might be thinking of to see if the state has a problem with that. Right. Counsel who calls a witness, unless it's clearly an adverse witness, in which case counsel needs to notify opposing counsel that they have not admonished that witness. But otherwise, counsel is responsible for ensuring witnesses are aware of orders in limine, otherwise clearly off testimony that is off limits. Make sure they understand, the Rule 615 requirements and the fact that they're going to have to sign an affidavit subject to the penalties of perjury that they have not watched this stuff. So it's your responsibility to make sure that they're aware, because when they don't comply, I'm going to be asking, why did you make them aware? I'm going to, while we were talking about the jury, I failed to give you the juror affirmation that will have to be signed by the jurors each day. Let me give you a copy of that along the same lines. So that is an affidavit each juror will fill out daily, indicating that they have not violated the court's instruction or otherwise been exposed to testimony or information about the case outside of the trial itself. If I exclude evidence and you need to make an offer of proof, the opportunity to do that generally is when the jury, when we're not working with the jury, such as the morning session or the afternoon session, so that you can make that record as best as possible. That can be done typically by simply making an oral reference to what the witness would have testified or what the evidence would have shown had it been admitted. Okay, I think the rules are pretty clear, but some judges may have more leeway than others about objections. Let me explain to you what my expectations are regarding objections. So objections to questions or exhibits should be stated simply and without argument. It should not be a speaking.
I think it just froze up on me again. Trying to look at the timestamp. Oh, it didn't.
Objection foundation requires a little more. As you're probably aware, there's case law that.
Last week, sorry to interrupt, but last week it would freeze like that and then it would just disappear.
Oh,
And then-
yeah. StreamYard's acting funny lately.
But it actually recovered. So, but I'm trying to keep an eye on the timestamp just in case it does, because I could always play this from a media player by sharing my desktop.
Okay.
But I'd rather do it through here because it's easier.
That is an insufficient objection. You have to identify what is missing from the foundation as part of your objection. If you think that doing so would put information in front of the jury that you're not certain I'm going to allow, please ask to approach. I tend to be a rather quick on rulings, on objections. I've been known to, testimony objection overruled, sustained immediately, without even giving you much of a chance to express your concern greater, because I can usually anticipate what the potential issue is and whether or not it's an issue. That said, if you think your ox has been gored and you need to address the issue more, either to have a record or in order to perhaps convince me that I'm maybe looking at it differently than what you anticipated, or than I should, please just ask to approach, and then we can have a discussion here at the bench about that. If you need to make a further record for any reason on an objection or in response to an objection, simply ask to approach and we will have that discussion. I'm sure by the end of the trial, we'll have to replace the carpet from the trail leading from counsel to the bench, but
Welcome back.
that's fine.
Wait.
As I've shown you before,
Hey,
the
welcome
court
back.
reporter
Sorry
will have
about
a
that.
device
It's okay.
like this that will allow her to hear through her earphones what we're saying. There will be white noise that's played in the courtroom so the jury and others cannot hear what we're talking about. There will be a physical barrier that blocks most of the view of the jury from what we're talking about at the bench that's rolled out so that they can't see. And we can have fairly fulsome whispered discussions here at the bench about that, whatever the issue may be. I have found in, doing this for far longer than I care to remember, that when I send the jury away to hear argument on an objection, what might take 3 minutes to have the argument on takes 12 to 15 minutes to get the jury back again. And then we lose a lot of time throughout the day that way. And so my preference is, as much as possible, to have those discussions here at the bench. Now, if it's a very significant issue that requires much more legroom, so to speak, to talk about it, then I will chase them out of the room, but I prefer not to handle the more routine stuff.
You know what's funny, Amy? You say this, but I kind of say the opposite. I'm willing to believe he's guilty, but I'm not so sure he is.
Yeah, I think
But-
I think we're at the same point where you believe maybe he isn't, and I believe like maybe he is, but we're willing to hear both sides of it to figure it out, right? Because it hasn't even happened yet.
You remember last year sometime we talked about this when he first came up with the stargazing thing. I joined you for one of your lives and we were like, oh, he's so guilty. I swear I really believed he was guilty up until like they found other DNA and like there's these other things. And investigators could very easily just get focused on one thing and stop
Oh,
looking,
yeah.
but maybe they shouldn't have.
Or even like create things they shouldn't. I don't trust police officers any more than the next person.
What if Kohberger knows there was somebody else there because it was his accomplice? And, pointing to that DNA might make him,
I
get the
think he's
probable
guilty
doubt
too,
or
Rose.
whatever.
I think he's guilty, but I'm willing to hear it all. I don't want to, I would not want someone to go to prison that just because they're creepy. He is a little creepy, a
He's
lot
definitely
creepy, but I don't believe anyone should be in prison just because they're creepy. I mean, but
Yeah.
Yeah.
Well, the judge has to treat him as if he's not guilty, but the prosecutors don't have to do that. And
yeah,
it's the defense's job to try to get away with it no matter what, basically.
he got lucky with the defense and she's good. He got
I don't
really
know
lucky
if
with
she
her.
is. If you really need to watch the first half of the motion hearings where they're talking about all this stuff that they're trying to keep out of court.
Mhm.
And like she came up with this idea and it was completely wrong. And the judge just made her look stupid.
Are you talking about the diagnosis idea?
No, it was a rule. Like I can't remember what rule it
Can't
was.
talk about his autism. That one.
No, it wasn't that. There was a certain rule. Like they were talking about Rule 415 earlier. It was another rule. And part of the way the rule reads, it sounded like the way the defense was kind of trying to push it, but it was like the judge is like, well, it kind of sounds like it fits, but it doesn't because of X, Y, and Z. And they kept pushing. And then finally he just said, you're wrong. That's the end of it.
Yeah.
And
Well,
I
I still think he's got. I mean, she's a public defender. He got the best that he was ever going to get, in my opinion, in Idaho. So.
I'm sure the public defenders don't mean they're bad attorneys or they.
But not all public defenders are death penalty certified. I don't think there's a lot of them.
certified.
Mhm.
I haven't looked at that, but I imagined other attorneys have probably talked to Kohberger to try to represent him for their little fame
You
or
have to be
something.
an attorney that can represent death penalty cases. You have to be death penalty certified.
Hmm. Yeah, so I don't know when they start talking about the one thing I actually want to hear, but
Is
they're
this
kind of
when she's
going,
talking about there's an accomplice? Is that what we're trying to get up to? Because
yeah,
that's what.
One of the
Yeah.
things about,
Okay.
I've
Because I
had
saw a
counsel
clip of
before
it, but I
who
haven't seen the whole thing yet.
confuse the idea of the need to make a record with the need to get my ruling and then offer a rebuttal to it. That is not making a record. That is making a rebuttal. And at least until it goes over to State Street, I get the last word, and not you. And so I don't generally afford that opportunity. So if after I rule and you tell me you need to make a record, it truly needs to be a record on something that for some reason you were unable to make when you had the opportunity to do so, and not simply to see what my ruling is and then try to pick it apart. I will reiterate what I started with is I don't like surprises. If you anticipate an objection or you anticipate objecting to testimony you certainly know is coming, let's talk it over before the witness hits the stand, before the jury's in the box, so that I have as much time as possible to be prepared so I can give you as best a ruling as I can, and so that you can make as best an argument as you can. If you anticipate the potential impeachment of a witness by prior testimony, whether that's grand jury testimony, whether that is transcribed witness interviews, whatever it might be, please get that to me before the witness hits the stand, and preferably towards the start of the trial, so that I have that available so I can have read it before the witness testifies, so that when you then ask to either impeach or to refresh recollection or whatever it might be, I will have read that testimony. Don't be mistaken in your belief that I have all that testimony. If it, for example, happened with Judge, I don't necessarily have all those transcripts, so get them to me. Or if I do, they're in one of 100 boxes somewhere back there.
Your Honor, if they've been supplied with exhibits and the purpose was just for that, will that be enough for the court, or should I have an extra transcript at the start of the day if I think I need it on paper for it?
So let me know as far as advancing possible, and I will have staff look for that. But otherwise, it's probably safest just to provide me an actual copy of it.
Thank you.
But while I'm thinking of it, because I'm in my mind envisioning the materials from grand jury that we have here, the state did file a motion to get back its exhibits for use at trial. I assume there's no objection to that?
No objections.
All right. Mr. Thompson, if you may make arrangements with staff here to get those while you're here, okay?
Yes, sir.
And I assume you have
maybe I
replacements
think
you have.
there is talk of a possible, like, depending on what the defense presents the court on Friday, the prosecutors have until June 6th to respond to it. But this will be kind of a crucial time, because if it is evidence that might, make him look less guilty, present a reasonable doubt, they could offer him a plea deal.
But
I
they
don't think
haven't
that
offered anything
I don't
yet.
think they're I haven't heard that yet. I've heard talk of a possible offer, but I haven't heard any. Like, it just seems like rumors at this point.
Yeah.
I think we'll know more as soon as the prosecutors respond to whatever the defense is going to present to the court on Friday,
Very
the
curious
23rd.
what they're going to present.
Yeah, well, the judge, if we can ever get there, he's like, well, we're not going to play this game. It better be real, basically. So It's gonna be interesting.
But
Or
didn't
we'll
they
get to the
file
further,
something? They just
those.
filed something like
Actually,
yesterday.
Well, they had until Friday to file it.
didn't
Maybe
they
they filed
just
it
do it?
earlier.
I swear, because I've been trying to catch up on this case for tonight, and I swear they filed something, and they asked, on top of that, they asked for an extension to the case because of the Dateline thing that just came out.
Yeah, that I haven't seen yet.
That
I heard about the
I saw
Dateline
today.
thing. I haven't watched it. I don't know exactly what Dateline showed everyone, and I just
Well,
don't always
you
have
can play
time.
this and let me look and see if I can find it.
Okay.
We had a procedural question we were going to ask the clerk. I'll ask Your Honor.
Clerk probably knows better than I do, but I'll go ahead and try.
We can do one of two things. We can either get together a set of photographs or copies of the exhibits and exchange those for the exhibits, or take the exhibits, document them, and then give the clerk what we've documented. We're happy to do it either way.
Well, my only fear is that you take the exhibit and then I don't know what the record is of what it actually looked like. Not to suggest that you would be involved in any chicanery and switching something out, but just trying as best I can to preserve that record.
Understood. So we probably will not pick them
Okay.
up on this trip, but we will make arrangements to have that done certainly well before trial.
Very well.
Thank you, sir.
Yeah, they did.
Speaking of chicanery, I'm not fond, and you folks know that by now, of making accusations against opposing counsel that are not well-founded and supported by specific actual evidence. I know that you can get along, but I also know that over the course of a trial, particularly a long one, tension rises. And so I remind you of that to be professional. Don't talk to each other directly when we're in court, right? When the session's going, everything goes through the court as you know, the protocol with courts generally is. Refer to each other by professionally, Ms. Taylor, Mr. Thompson, not by first name while we're on the record. Again, avoid making accusations that you don't have the tickets for, or the receipts for, I should say. And under no circumstances should you make such accusations in front of the jury. It's a long trial, so as much as I want you to be prepared.
Oh no. What's the time?
They
20
I
minutes.
have a local witness
Yeah, it worked.
and a witness who's flown in that needs to get out again at the end of the day. And so it may be that we need to stop one witness's testimony to get the other witness in and then pick the other one up. As long as there's no clear prejudice from that, I'm generally flexible in allowing that so that we can accommodate that. And I ask you to both be accommodating to each other in that regard. All right, any questions about witnesses' testimony?
Just one, it's kind of a takeoff of what the court just mentioned. We have at least one, maybe a couple law enforcement witnesses in particular who have testimony relevant to different stages of the case. And it's our intent, with the court's permission, to call them at different times instead of trying to figure out how to call them once and have them talk about what's going on at this stage of the case and then what may be happening next week with the case. Is that acceptable to the court?
Well, let's start with whether it's acceptable with Ms. Taylor.
Your Honor, I don't know that I have a strong objection or really any business in telling the state how to put on their case. That feels really cumbersome to me. I was hoping for leeway the other way when we would call a witness ourselves, but they're a state's witness, I'd hope to have a little leeway to do all of my examinations so they didn't have to come back. I would otherwise defer to the court.
Certainly, if you're, somebody's on your witness list, if you want to go beyond the scope of direct as part of effectively your case in chief in advance, I don't have a problem with that. And so if it's going to save bringing another witness back, I don't have a problem with that. I don't have a problem if it doesn't get too cumbersome. If, you know, if we're having a law enforcement talk about a broad area of one phase of the investigation at a time, that's probably okay. But, you know, having them come up and narrate between every other witness is probably too much. Then the question becomes is how do we handle cross-examination? And basically I will defer to the defense on that or the other side on that to the extent that we allow, which is, do you want to cross-examine about the information they just presented now? Or do you want to wait until their last presentation and cross-examine about everything? And so that'll be up to you.
Governor, with that said, then I guess I'd request that the state let us know when they call a law enforcement that's for a limited purpose right now, but is coming back for another purpose.
Yeah, they need to let me know that as well.
Yes, Your Honor.
And if you don't let them know that, and you know, well, either way, it's your responsibility to ensure that they're back at some point available to the defense so that they can cross-examine, even if you decide, oh, I don't need them anymore. You know, you better not send them on an airplane somewhere where they're unattainable, because the remedy may be to strike all of their testimony as a starting point.
We would anticipate asking court and counsel if this witness may be excused if we're finished with them. And then I would give Ms. Taylor or other counsel an opportunity to let us know whether they still need that person.
Okay. Likewise, when you look at each other's witness lists, talk with each other and then write it in, get it in writing so we have it as to whether or not, for example, Ms. Taylor will need some.
And it just finally glitched. Where was the time at? Oh, wait, it's still up there. 33
I don't know.
minutes.
I wasn't looking at it.
Yeah, this is what's been happening. I don't know if it's these longer clips or if it's just how StreamYard is, but I pay way too much money to do this.
But I did look it up, and they did ask for the defense filed a motion that argues that rescheduling the trial will mitigate the prejudicial effects of negative publicity following the May 9th Dateline program. The report featured data allegedly found on Kohberger's cell phone, including searches about serial killers and images of college-age women in bikinis.
Yeah, well, I think that's where they got the porn search information, right? Was that where that all came from?
Yeah, from the Dateline thing.
Yeah, because the stuff he was searching was very disturbing. Like it went a little beyond, academic research. It was like he was actually trying to become Ted Bundy.
Well, yeah, and then when he was looking at the YouTube videos about Ted Bundy, and then the next thing you know, he's in a photograph where he's dressed like Ted Bundy was. It's just very strange.
Yeah. I mean,
I can see how you could try to put a story together and try to make anything could look strange if you spun it right. So, but I mean,
true.
The fact that he was wearing gloves, putting through the trash and stuff, and he had never done that before. That was if he had a new tick about him.
Yeah, I don't think he's I don't know. They were pushing to talk about his autism, and from what I've gathered, he's the lowest level on the spectrum.
Yeah, I think he would have even been Asperger's. If Asperger's was still a thing.
Isn't Asperger's like just one of the
They
degrees
took
of
it away. They took
autism
it
now?
away. Now it's just all levels of autism.
Yeah, it's a spectrum of stuff. And he's supposedly at the very lowest level. I mean, he's high functioning, right? He's
Yeah.
in college.
Mhm.
He's working with his peers. He's doing all the research. He's passing all the tests. You know, I don't know. I don't think the judge said that they were going to talk about it or not talk about it. It just kind of sounded like it was a waste of the judge's time to even consider it. But they're going over the rules mostly. So the judge is trying to protect himself. He doesn't want to sit through this whole thing for months and months and months. And then at the end, there'll be a technicality and it goes to a mistrial. And then, if the
Yeah.
defense team has a second chance, they're going to know everything that the prosecutor is going to throw at them, and they'll
Yeah.
have a defense for it. So that jury is going to, it's going to be harder to convince that jury that he's guilty. Because once you know everything, then it makes it a little easier to defend it.
They'll
So the
also know
document
what
itself-
he's gonna do, what's under his sleeve too. So, but I think that it would be good if they could just push this through. Wouldn't it be crazy if Bryan Kohberger was found guilty and he faces the firing squad? Like, that's insane.
All I can think of is the Ted Bundy clip where he's like, "Oh, I got more of a chance of dying of old age than I do of facing a firing squad." Something crazy like that. And he's laughing about it to the reporter guy. I'm like, Jesus. I think he got the gas chamber, right? Didn't he die?
I don't remember how. I thought it was the electric chair, gas chamber. Well, it would have been in Florida. So, however, Florida was doing it those days.
Yeah.
Florida just put another person to death last week, Glenn Rogers.
Yeah. I don't know. I think the death penalty takes too long. I think there should be no death penalty too. I don't know. It's like conflicting thoughts on
I'm
that
not
topic.
like for the death penalty, but I'm not against, like, I'm not gonna like lose my mind over it either.
Yeah, I just know when these guys spend like 40, 50 years in prison, that's a lot of money that, spent keeping these guys in custody that, if they did it the old fashioned way, we wouldn't have these people, causing more problems. But
Well,
at
a
the same
firing
time, I
squad.
definitely don't want to be the executioner. So I can see why some states don't have the death penalty. I wouldn't want to be a judge and, have to rule you get the death penalty. I wouldn't want to be on a jury that has to do a death penalty either. I just would feel weird.
Well, that's what they're worried about. They're worried they're gonna, because on a death penalty, you have to get a specific kind of person that will say, yes, I will put a person to death, and it's usually a white man that will say that. So they're afraid that it's gonna be stacked with all white men, and Bryan doesn't want that.
Yeah, they're gonna get to pick. Both sides get to like eliminate some of the jury members, and
But it's harder to find a person that will say, yes, I will put a man to death. So it will be very limited who they're going to be chosen from. And then even limited now, even since the Dateline, it's going to be even more limited from someone that's not going to be biased against it. It's going to be hard.
Well, there's some people that haven't watched it, like me. I haven't seen that yet. There'll be some people that don't watch the news specifically, so they don't have to see this
that
kind
live
of stuff.
in Idaho. Okay. It's going to be hard, Robert. I don't know why you're fighting with me on everything.
Well, I don't think
but
that
it is.
the normal number is 10,000 jurors. They're going to select from 10,000 people. That's not normal.
They asked to move it because they were so worried. They asked to move the trial because they're so worried about who they're going to be able to choose from. I don't know why. Okay. Anyway.
Yeah, I think it doesn't. It's not like uncommon for them to move, to a different city or a different part of the state. But I mean, yeah, it is definitely going to be hard. It's going to be really hard.
The firing squad uses multiple officers, so the officer won't know who actually did it, whose bullet actually did it.
Yeah, I've heard that they put blanks in some of the guns.
Yeah.
But, if I was one of the firing squad, I'd be aiming, to the side.
But I couldn't even be the person if I was like injecting the fluid to
Ugh.
unalive the person or hitting
Pull
the
down
lever
the
to
lever for
electrocute them.
oh
I just
god.
couldn't do any of it. So
Mhm.
I couldn't. I don't think I could unalive somebody unless they were trying to unalive me.
Yeah, if it's a reaction, that's different
Yeah.
than, waiting 40 years and then finally doing it.
Yeah.
I wouldn't want to live that way, so I hopefully never get the death penalty. Because to live knowing you got the death penalty coming, that's got to suck too.
Well, I wonder what death row is like in Idaho. If it's like nice or if it's worse, because it depends on the state. Some states it looks like it's better to be on death row.
I
And in
saw a
other states it
documentary
doesn't.
that agrees with that. Like people want to be on death row so they get a little bit better living conditions.
Yeah. You usually get your
Oh,
own
that's a-
cell.
Yeah.
But the guy from the West Memphis 3, I used to follow that case quite a bit. Damien, he had a really hard time on death row. He said that he even lost his eyesight, the ability to see farsighted, because he wasn't able to look far away. He was only able to look at what was up close in front of him. That's why he wears those glasses and they never dim the lights.
Wow. That's something I never even considered, that you could lose your vision if you can't actually look far
know.
away.
Isn't that
That's
crazy?
crazy. Yeah. That is really crazy. I might actually have to Google that because that seems kind of interesting. I had no idea that's even possible.
I didn't
You
either,
know-
but I heard it. I heard Jumpsuit Pablo say the same thing. The guy Jumpsuit Pablo that was in North Carolina. He's a YouTuber. He does the Wade Wilson stuff quite a bit. But yeah, he said the same thing about his eyesight. He started losing the ability to see far away.
But, it also happens with old age. These guys are like in their 40s and 50s when this
Yeah.
happens, or are they in their 20s
Pablo,
or 30s?
Jumpsuit Pablo is still in his 30s.
Okay. That does
And
seem.
this Damien was still in his 30s. He was actually a teenager when he was sent away.
Man.
Got out in his 30s.
I think people should be more afraid of living in prison.
Oh, I know a lot about myself. And I know that this girl cannot go to prison. It cannot happen. So,
Okay, to go back and do more work. Where are we at on that?
he is so irritated.
Ms. Jennings can
I don't
speak
think
to
he's
that.
irritated. I think he's just.
I think he
Your
is.
Honor,
I believe
nature.
that we've submitted
got his
all
hand
of
on
the
his
certificates
face.
of authentication for all the exhibits we plan to introduce that way.
Okay. And you submitted those to the defense to review? And Ms. Taylor, are you going to respond to those?
Your Honor, we did. We met with the state last week, I believe, or the week before, and we discussed some of those records. There were some issues with them. Ms. Jennings provided me with a thumb drive, and I don't know if those have corrections on them, but I'll continue to let the state know what we think, if we continue with an objection or if we're satisfied that the rule's been met.
Okay. If you could get with each other and then provide me I didn't study the exhibits that I got a day or two ago, or the spreadsheet that closely, but make sure I'm aware specifically of which exhibits there is no objection to the self-authenticating or otherwise not an objection to authenticity. Doesn't sound like we're going to need a hearing on that, at least for the time being, though.
Not that I'm aware of now, but certainly we'll keep our eye on
I'm
it.
trying to
I
look for
can
the
alert
timestamp
the
for
court, and if we can
what I
squeeze
want
it
to
into
show
June
you
18th,
guys.
that's
How long
possible.
is
Maybe
the-
we
Sure.
can start that at
How
noon.
long is the motion hearing?
Okay.
This thing is like 2 hours.
Oh,
I think.
dang. Okay.
I don't know.
Well, you should find it because we're coming up at an hour and a half almost. Let me look over in chat while you look
And then
for
I
it.
would certainly caution, at least because the state goes first for now, I'll say the state, that, belts and suspenders are good ideas when it comes to trial. So I would have my people I need to authenticate things under subpoena, just in case. especially if they're out-of-state witnesses, because that's not something you can do overnight. So the methods of displaying evidence to the jury, generally there's 3 ways to do that. One is by putting it on the Elmo and projecting the physical document, whether it's a writing or something else. The other is if it's a writing or something else, using litigation software of some kind to project it through the computer. And the third is passing it through the jury. That last one is the one I want to avoid as much as possible because that just takes too much time. So try to use the other 2 approaches as much as possible. Now, there are going to be some physical objects that it may be important for the jury to see, and I get that. But in general, you know, photographs, things that are in writing.
Did it just freeze up again?
Here, I think I found a clip of it.
I think my thing froze up again.
Did it? I think I found a clip of it. Hold on. Or unless you can fix it.
No, I'm gonna have to. It's not playing anymore.
That
Oh wait.
But and try not to make the notebooks bigger than about 1.5 inches each, at least on the copy you give to me.
If I knew the timestamp, I would be able to just.
Sure.
My plan was to watch most of this before I started, but I didn't get home in time.
Here, let's see if. Yeah, I can't share it when there's something up there, so
Oh,
you'd have to take what's up there down. Okay, let me see if it'll let me share it. Is
hey
it up
Ron,
there?
you made it.
I don't.
Nothing's. Oh, there I see it.
There.
I've got no.
Just today in a courtroom in Boise, Idaho, pretrial motions were underway. Both sides there inside, kind of hashing out some of these logistical concerns before this trial gets underway later this summer in August here. So we did learn quite a bit about how this is all going to go. I guess for journalists, it's important for us to see this, watch it live as it happens once it does get to trial. And the
So
trial,
they hashed out how the journalists are going to be able to cover this, or
They're planning everything, how everything's going to go.
which is scheduled to begin August the 11th, will be live streamed. That's according to Judge Stephen Hippler. He ruled that today during this hearing. So Hippler also agreeing to a request from prosecutors to shut down the live stream when the surviving roommates are testifying. So that's a key kind of detail there as well. Now, the judge also said during the hearing, jurors will consider whether to impose the death penalty or life in prison without parole if Kohberger, of course, is found guilty. Obviously, you need a conviction to even discuss the penalty phase. But this trial is expected to last several months here. So in the meantime, we do have some of our reporters standing by there in downtown Boise who was following.
they should have. Here it is, right here.
Certainly counsel and the defendant proceeding have the right to be present, but when the questionnaires are administered. But I suggested to you that perhaps your time is better spent in reviewing the questionnaires than watching people fill them out. The process will be such that as we bring groups in to fill those out, those will immediately be scanned and then provided to counsel on a shared drive. And so I guess I wanted to get your feedback on whether I suspect this is a all for one or not proposition.
Thank you, Your Honor. My understanding is we have both agreed that there's no need for counsel from either side to be present during that stage. We'll focus on the tasks at hand.
Okay, Very well. Is that the court, Ms. Taylor?
Please, Your Honor.
All right, very well. So as I indicated, you'll be given access via shared drive. You can do two things. One, you could save those over to a copy over to a drive in which you can make edits, or you can print and make hand edits, or you can just keep track by notebook and juror number. If you want to do the printed version, you'll need to bring your own printer and supplies in order to print those off from your war rooms.
So that's the juror questionnaire they're talking about now?
Mm-hmm.
The plan will be to take the universe of jurors who are summoned and then scramble them randomly and assign them what we call a scramble number, 1 through 10,000. And then we will bring them in to fill out the questionnaires beginning with 1. So that the questionnaires that you receive first will be the jurors most likely to be in the line of fire, so to speak. Because once we have enough jurors, we'll stop. So that's the plan. Anybody have any concern with that?
No, sir.
No concerns, thank you.
Technically, under the rules, you are entitled to watch the scramble process, which literally involves the jury commissioner hitting a button. I don't know if any of you want to be there for that.
No, thank you.
We'll waive our presence for that, Your Honor.
Very well. I do want to stress the security and confidentiality of the juror questionnaires. As I'm sure you're aware, pursuant to Criminal Rule 23, those are extraordinarily confidential. The copies that you receive will be, we'll maintain a copy, obviously, for appellate purposes. The copies you receive will be returned. And the defendants, they're supposed to be essentially attorney's eyes only. I'm fine if you both agree to allow an investigator to see, so that they can be doing, whatever online investigation they feel appropriate as you go along. Doing that, in terms of the defendant, his access has to be with attorneys present. In other words, he can't have a copy to go back with him when he's not with you.
That makes sense, but I have one question for the court. In addition to our investigators, we have 3 that are working on the case. We would request our paralegals be allowed to assist us. Just with the magnitude of the task, we'd like to have the assistance of our paralegals in organizing and reviewing.
Okay, so I wanted to just kind of give you a sense, a taste of this in court today there in Boise. But you see there Bryan Kohberger in the white dress shirt and the tie with his team of attorneys. Of course, the man accused of killing 4 University of Idaho students. He was back in court today.
So I don't think they actually show it unless it's right here.
Potentially fairly objectionable in terms of
Yeah, I think
admissibility. What you had put in there was fairly
alternative suspect, and they submitted some mailed documents to support that claim. But the judge said today that he still has questions.
It seemed to be much of what you had put in there was fairly potentially fairly objectionable in terms of admissibility.
Travel.
Judge Hippler is giving the defense until next month to provide more details. Kohberger sat quietly in court today wearing a white shirt and tie. He's facing 4 counts of first-degree murder and 1 count of burglary, accused of stabbing 4 University of Idaho students in their off-campus home more than 2 years ago. The judge.
Yeah, so that's where it was.
Yeah, but they're supposedly going to be submitting something by Friday.
It said next month. It said next month, but you heard by Friday?
The 23rd is what I have written down. I guess it could be wrong, but
I don't know. It just said by next month. So, but you said you heard Friday. So,
well, what I heard was that the defense has to file something by the 23rd. So they had like a week, and then the prosecutor has until June 6th to respond. And then I think they're going to decide, the judge is going to decide on it a couple weeks after that.
well, here this was just posted 4 hours ago, and this is Bryan Kohberger's defense team seeks to postpone the trial. They filed that.
Yeah, I'll have to look at the transcript to find it. But I know they talked about it. I know there was like these deadlines. So
Oh, there's another book coming out too. Did you know that?
on this case,
Yeah, the motion that they filed also said that also referenced the forthcoming book by author James Patterson, The Idaho Four, An American Tragedy, scheduled for release on July 14th. The defense states the book's description of Kohberger as a brilliant grad student, loner, apparent incel, and the publisher's boast of unmatched access to the investigation includes interviews with local law enforcement, further demonstrates the need for a delay.
I don't know. I would read the book. I can't
Yeah, I
imagine.
would too. Wow.
But that author writes fiction,
I know.
so it's going to be really good.
Woohoo! James
Yeah.
Patterson.
Yeah, but I don't know I can't find it. I know I found it the other day. I even just asked ChatGPT, and it doesn't even know what I'm talking about. But sometimes it works, and sometimes it doesn't.
I've been using ChatGPT for a lot of stuff lately.
I use it for almost everything. It seems like when I Google stuff, I don't use Google anymore. I ask ChatGPT, and then it could find me links.
Gives such a better answer, ChatGPT.
Well, have you noticed when you go to if you open up like Microsoft Edge and you type in a question, the first response is actually an AI response now. It ain't just a bunch of list of websites. So I think it's the future. The AI response is going to be the future.
Yeah, well, for sure. Yeah, see, it's going to be next month, June 18th. A hearing is going to be held to discuss the defendant's evidence that alternative perpetrators were responsible for the quadruple murders.
Yeah, I think that's when the judge makes the decision, but there was deadlines before that. I'll have to find it, and then I'll email you and show you. Because then the judge has to deliberate on whether or not to make the decision after they both have talked about it, both sides. So
but it says a hearing, though. I think he needs to hear it. I think maybe they have to have it in by tomorrow or whatever, and then the hearing is going to be set. I don't know, but they said, but in the footage we just watched, they said next month.
Yeah, I agree. I don't know. I don't have a good answer. I know I found out. I found out about this a couple of days ago, but I don't have specific details right on hand.
I doubt this case is going to happen in August. I do.
Well, they're going to want, obviously the defense wants to delay as long as possible. They want to, mess up the prosecutor's, rhythm, right? I think one of the tactics they were talking about how sometimes one witness could, maybe we could squeeze in a witness here or there, but neither side wants to mess up the way they're setting up their witnesses, because the way the witnesses come in is how the jury gets all the information. So they're telling a story with these witnesses, and if one side interrupts that storytelling process, it could really have a big effect on the overall verdict, I think.
It's going to be the case of the year when it starts, when it finally happens.
Yeah, the next one I think is going to be the Long Island serial killer guy.
When's that one supposed to happen?
I don't remember, but they just found more bodies a couple months ago, and they found all this stuff. But the weird thing with the DNA was it wasn't straight DNA. It was trace DNA that was said that, he was related to, it was a maternal DNA thing or something. It wasn't just regular DNA. So if he had a brother, it could have been his brother's DNA also. But as far as I know, there isn't a brother for that case, but
I don't know that case well enough to really say. It's been
you
so
should
long.
watch the Netflix documentary. They talk really more about the victims that they do find. It's actually a pretty good story. I know I've written about the Long Island serial killer a couple of times, and I find it very interesting. But the one I saw on Netflix, the way that they talked about these victims, these are sex workers that are being killed, but it made me like think, oh my God, these people were real people too, instead of
Yeah.
just like, oh, it's a sex worker. I mean, it's hard to see it from that side all the time when you're looking at all these different cases all the time,
Do they ever come out? And because the only one that I remember is the one that she was racing around the neighborhood. She called the police, and the guy who drove her out there.
They were looking for her when they found the other 4 bodies.
Did they ever say what happened to her? Why she made the calls?
In the documentary, I believe it's Netflix. It might be Peacock, but they questioned the pimp, the guy that was giving her rides to her dates, and they don't think he was involved in it. But he said that she was acting weird. He went to pick her up, but then she didn't show up, and he saw her run off into some bushes or something.
Did they ever say who did it to her? What happened to her?
Well, they know she died, and that's about all.
Yeah, and she ran out of her pants. I mean, that doesn't happen, and you don't run out of your pants,
right? But she could have been on drugs and had this weird thing happen. I mean, it's hard to say really, but I didn't actually finish all of that documentary, but it is really good.
Okay, well, I'll have to look at it.
I have a hard time actually watching TV. I get maybe 15 minutes, and then I'm usually writing, or mostly just writing and editing.
Oh, I love TV. I've been watching Animal Kingdom lately. It's really good.
I've been trying to watch Supernatural for a while, and I've been on I watch maybe 10 or 15 minutes a day.
So I watch too much.
This one episode where there's a time travel episode, and I don't know. It's my 4th day watching it, and I still haven't finished it. But I don't know. I spend a lot of time on YouTube, so I usually get home, then I spend 3 or 4 hours on my channel, and then go to bed and do it all again the next day. I never have enough time for anything.
Oh, well, you got to make time.
Well, I don't know. I enjoy writing, so.
You're a good writer.
Thanks. Well, guys,
do this again.
What's that?
We should do this again. I'm going to start back with the Idaho Four case, because I don't know if it's going to start in August, but I want to get caught up with it.
Well, they're going to be streaming everything, and I think this hearing what could have been streamed, and I remember a couple of years ago you were telling me, oh yeah, you can restream all these court cases. I've never tried, but I need to figure out how to restream a stream.
Only they only allow certain news stations to stream the trial, so you just go to their page, the news station's page, and you just share the page and you stream it like that.
Yeah, I don't know how to do that. It sounds easy, but when I try it, I know it won't be. So
no, it is. You literally just put the page up on your screen like we just showed with
I see.
And you just play it. You just show it.
That would be,
it's easy.
That would be yeah. But it should be an interesting one. And if you get a chance, you should look at the 3 hours of motion calls. I did a live stream on it, and I only showed the first half. But you could see every little thing that they're trying to put in and take out, and it really paints a story. And it's a story the jury's not going to see. But it kind of also gives you these. This is why all this information's coming out now, is because of that hearing. Stuff has trickled out just through that.
Yeah.
But it's really good, and this is a good case to actually follow because it's easy to like pick out the characters and learn about them. I mean, the judge is really cool. I mean, I know he sits there like this, or what was he doing like this, peeking through his fingers. The first time I saw him, I was like, wow, this guy doesn't want to be here. But actually, I think that's just his personality. I think he's just done this a lot. He probably is thinking, oh, can't believe I got to go through all these stupid rules all over again. And, because if we don't, somebody's going to do something stupid.
I don't know. Some people are just like that too. I'm like that when bullshit's coming at me. I want to block it, and I have no patience for it. And it doesn't mean I'm an asshole. It just means I don't have patience for it. So I think that's what the judge is. He just doesn't have patience for the BS, right? Like,
I don't know. He seems very patient. He really does seem patient. Like he listens. Like you'll just have to watch it, and you'll see what I mean. Like he really listens to those defense attorneys until like finally he's like, you know what? This is like 30 minutes later. He's like,
okay, but when someone has their hand on their face, to me, it says a different thing. But
yeah, I wouldn't want my attorney to be sitting there like this, while we're in court, and he's like, objection, Your Honor. Same thing as before. I could just.
In fact, I think I want to walk around like that. I'm just going to walk around with my hand on my face. So people just think I'm annoyed. Just leave me alone. If you think I'm annoyed, I am annoyed. Okay. Well, thanks for having me on.
Yeah, it was fun. This is it's an interesting case, and I don't know what's going to happen. I have a lot of like thoughts on what is going to happen, but I could be completely wrong.
Yeah.
And, I think that's why people need to watch this, because anything could happen. Literally anything could happen.
Yeah, it's exciting. It's a good case. I agree.
All right, guys. Good night. Thanks for stopping by. I am planning to do another stream on Sunday. If I get a chance, I might do one sooner. I've got several things I'd like to talk about, but I haven't picked any topic yet. So if you got an idea for something we could talk about on a live stream, just leave me a message on any of my posts. I check all the comments and stuff, and I'll consider it. But good night, everyone. I had a lot of fun. Thanks, Amy.
Yep. Thanks for having me here. Bye, everyone.